Here we are again, the long list of mass layoffs from just this week. Check out a recent video I did, past article I wrote, history of mass layoffs. But right now I want to talk about the WARN Act. The WARN Act is the Worker Adjustment and Retraining Notification Act, which requires qualified employers that intend to carry out plant closings or mass layoffs to provide 60 days' notice to affected employees, states, and localities. If you were laid off, did you get 60 days notice in advance? No? I didn't think so. The purpose of the WARN Act is to give notice to workers, allow them to seek alternative employment, arrange for retraining, and otherwise adjust to employment loss. The purpose of giving notice to localities and states is to allow them to promptly provide services to located workers and otherwise prepare for changes in the local labor market. A layoff has impacts beyond the individual. Who does the WARN Act apply to? Maybe that's why you weren't notified. It doesn't apply to your company. Probably also wrong. The WARN Act applies to employers with at least 100 or more employees. This is with the exception of federal, state, and local government employers. Broadly speaking, there are three types of events that require notification under the WARN Act. Offense is limited to a single site of employment. Employment losses by a single employer across multiple sites are not aggregated. The question here is, what about remote employees? Are they then exempt too? These details just not figured out. Our legislation hasn't figured out the modern world. Back to the three types of events. Plant closing resulting in employment losses of at least 50 employees. Second, a mass layoff of at least 50 employees where the employment loss consists of at least 33% of the employment at that site. This might be how employers are getting around it. They lay off less than 33% at a specific site, or divide that percentage around different sites. Could even lay off 15% of their employees the first Monday of the month, 15% on the second Monday of the month, and they wouldn't qualify for the WARN Act because they're doing it in smaller increments. Finally, the third criteria, mass layoff with an employment loss of 500 or more at a single site of employment, regardless of its proportion of total employment at the site. This criteria is so specific yet so broad that it seems not to encompass any company, especially in the modern work world. Exceptions could probably also exempt all of our current companies as well. Exceptions relate to layoffs that are triggered by unanticipated situations, such as unforeseeable business circumstances. Basically, any company could claim that, and they basically get to with all the loopholes that there are for corporations. WARN Act is enforced through the federal court system. If a company is planning layoffs, this list is what they should do. Employees should get 60 days written notice before the layoff. Companies usually get around this by paying severance after the layoff in order to avoid legal fees and lawsuits, but that's still not the law. So what is the WARN Act doing for you? This modern work era, basically nothing. Were you alerted by the WARN Act of your layoff? Share in the comments if you were or weren't.